I stand before you today not merely as the Minister of Defense, but as a Nigerian who has dedicated his life to the protection and preservation of our beloved nation. What I am about to share with you is born from extensive consultations within the highest echelons of the Tinubu administration, security councils, legal advisors, and stakeholders across the Southeast and indeed across Nigeria. The matter I address today has been one of profound national sensitivity, and I believe the time has come for transparency, for honest dialogue, and for a path forward that serves both justice and national unity. I speak today about Mazi Nnamdi Kanu and the conditions under which his release from detention could be considered by this administration. Let me be unequivocally clear from the outset, this is not a political statement made lightly, nor is it a unilateral decision. What I present to you today represents a carefully considered framework that balances our constitutional obligations, our security imperatives, and our commitment to the rule of law. It is a framework that His Excellency President Bola Ahmed Tinubu has authorized me to present to the Nigerian people as part of our administration's commitment to resolving long-standing issues that have contributed to division and unrest in our nation. For years, the issue of the indigenous people of Biafra and the detention of its leader has created a complex security challenge in the Southeast. As Minister of Defense and as someone who has commanded troops on the front lines of Nigeria's security challenges, I can tell you without reservation that sustainable peace is never achieved through detention alone. It requires dialogue, understanding, and sometimes difficult compromises that serve the greater good. Our security forces have worked tirelessly to maintain order and protect lives and property across the Southeast. But we have also witnessed how this single issue has become a rallying point for various forms of civil disobedience, protests, and unfortunately in some cases violence.
Every Monday sit-at-home observed, every business that closes out of fear, every student who misses school represents not just an economic loss but a tear in the fabric of our national unity. The Tinubu administration came into power with a clear mandate to unite Nigeria, to revive our economy, and to ensure security for all citizens regardless of ethnicity, religion, or political affiliation. We cannot achieve these goals by ignoring the elephants in the room.
We must confront them head-on with courage, wisdom, and a commitment to justice. Now let me address the legal dimensions of this matter, because some will ask, how can the government consider releasing someone who faces serious charges of treason and terrorism? We must confront them head-on with courage, wisdom, and a commitment to justice. Now let me address the legal dimensions of this matter, because some will ask, how can the government consider releasing someone who faces serious charges of treason and terrorism? The answer lies in understanding the full scope of our legal system and the prerogatives available to the executive branch within our constitution. The President of the Federal Republic of Nigeria possesses constitutional powers under Section 135 of the 1999 Constitution, which grants him the power of prerogative of mercy. This power allows the President to grant pardons, reduce sentences, or grant clemency to any person convicted of an offense against the laws of the Federation. However, and this is crucial, Mazi Nnamdi Kanu has not yet been convicted. His trial is ongoing, which presents a different legal scenario. Nevertheless, the Attorney General of the Federation, operating under the Constitution, has powers under Section 134 to discontinue criminal proceedings at any stage before judgment is delivered. This provision exists precisely for circumstances where the public interest, national security, and the pursuit of justice may be better served through alternative means. But here is where I deliver the core message that the Tinubu administration wants every Nigerian to understand clearly. The release of Nnamdi Kanu from detention is not impossible. It is in fact achievable, but it cannot and will not happen in a vacuum. It must be part of a comprehensive framework that addresses the legitimate security concerns of the federal government while also addressing the grievances that have fueled separatist sentiments in the Southeast. The Tinubu government has identified 5 fundamental conditions that must be met for the consideration of Nnamdi Kanu's release. Mazi Nnamdi Kanu must make a public, unequivocal statement renouncing violence as a means of political expression and acknowledging the indivisibility of the Nigerian state. This is not about suppressing free speech or legitimate grievances. This is about ensuring that whatever dialogue follows his potential release does not serve as a platform for renewed calls for secession or violence against the Nigerian state. We live in a constitutional democracy. Every Nigerian has the right to advocate for political change, for restructuring, for greater autonomy within their regions, but this must be pursued through constitutional and peaceful means. The moment anyone, regardless of their following or influence, in this moment of Nigeria, they cross a line that no responsible government can ignore. The Eastern Security Network and other armed groups operating under the IPOB banner must be completely dismantled. There can be only one legitimate security structure in any sovereign nation, and that is the structure recognized and controlled by the federal government. We have seen what happens when non-state actors maintain armed wings chaos, extortion, violence against innocent citizens, and the erosion of state authority, Nnamdi Kanu must use whatever influence he possesses to ensure that these groups lay down their arms and reintegrate into civil society. The federal government, in turn, is prepared to offer rehabilitation and reintegration programs for individuals who have been involved in these groups but are willing to renounce violence and return to lawful civilian life. For national security purposes, Mazi Nnamdi Kanu must be willing to cooperate with security agencies to provide information about networks, funding sources, and individuals involved in violent activities carried out in the name of IPOB. This is not about betrayal, this is about accountability. If, as he has sometimes claimed, the violence carried out in the Southeast was not authorized or directed by him, then he should be willing to help identify those who hijacked his movement for criminal. If he genuinely wants peace for the Igbo people, then he must help us distinguish between peaceful agitators and violent criminals. The release of Nnamdi Kanu must be accompanied by his commitment to participate in a structured national dialogue on the grievances of the Southeast region. President Tinubu has made it clear that he is open to conversations about restructuring, resource control, regional autonomy, and other issues that have fueled discontent across various regions of Nigeria.